Okay, well, good afternoon, everybody. This is Brad Campbell, one of the founding principals at Capital Rock Investments, and I'm here with Bob Kleinecht of Oakstone Law, and we've also got Philip Morrissey, who is a Capital Rock portfolio manager and advisor in our Aventura office in North Miami on the East Coast, and he is conferencing in via telephone to help us out with this broadcast today. This session is the second in a series of sessions on trusts and estates with my guest here, Mr. Bob Kleinecht, and the title of this particular session is Lightening the Trustee Burden. So today we're going to talk a little bit about who the typical trustee is, how that trustee is appointed to his role, what his duties are, how he may delegate some of those duties to relieve some of the burden and liability. And Phil Morrissey, who is a former longtime trust portfolio manager at SunTrust and Bank of America, will help us navigate and discuss some of the investment asset aspects of trust work, pitfalls, and some of the tensions there between competing interests of beneficiaries. So we're going to do this just like we did the first in the series, which is recorded and available on the Capital Rock website, as well as Bob's website too, I believe. If you want to catch up with us on that, those will be available, and this will be recorded and available as well. So I think what we'll do is start out with an initial question. This will be sort of an interviewee format, and I'll be sort of the moderator here with Bob and Phil, directing questions towards them. So to get us started here, Bob, if you could kind of walk us through who are typically named trustees, who appoints and selects a trustee in the first place, and does the trustee have to be what we'll call a known trustee, such as the Northern Trust, SunTrust, U.S. Trust, or some sort of entity or organization that has trust in their name, for lack of a better way to describe it?
Well, this is really the key question, Brad, and doing trust and estate planning for a long time now, this is often the question that is most challenging for clients, and that is so much of the estate plan or the trust plan really hinges on who this trustee is, because this person has a lot of discretion and makes a lot of decisions and really impacts the lives of your loved ones if you're doing the planning. So really a key question as to who is the trustee, and really you have a couple main ways to go, and that is first an individual trustee, which is just a human being. Alternatively, you can go with a corporate trustee, which is typically a bank or trust company. There's a new sort of hybrid that's out called a private trust company, which is probably a topic for another day, but that's a corporate trustee that's created by one family just to serve that family. But basically the two choices are individual or corporate. A lot of people select an individual trustee because they think it's going to give the family that more personal touch. Conversely, a lot of people select a corporate trustee because they're looking for somebody with structure and a really rigorous processes and just a very thorough, like I said, process in determining distributions and investments. So as far as who appoints this person, the grantor of the trust or the trust creator will name the trustee directly in the trust document, right, whether it's a person or XYZ trust company. And then typically with a well-structured trust agreement, you'll go ahead and name a successor, which is almost harder than naming the first in many cases, because once you've picked that great trustee, now you have to kind of think of a backup plan. What goes hand in hand with that is a mechanism in the trust for selecting a successor if someone is unable to act down the road and you're no longer there to make that decision. So the typical trustee, just more directly to answer your question, if it's an individual, it tends to be a family member or sort of a trusted family friend. If there's an operating business, I've seen this several times, where a client will select sort of the CFO type or the right-hand man, a long-term employee as trustee. Uncle John. Some people name their spouse. Some people name a child. Typically, there's one of the children that's favored for whatever reason, did well in school or what have you.
Sure, sure.
That sort of thing. And as far as selecting a corporate trustee goes, I think that really comes down to interviewing a few of them. And if you don't already have a relationship with a corporate trustee, just getting comfortable with that relationship.
How permanent is the trustee appointment or selection? How easy is it to replace a trustee? And in some cases, the grantor of the trust is no longer alive. What sort of flexibility can be built in to replace a trustee, whether it's a corporate trustee or an individual trustee?
Okay, great question. That is kind of the key distinction. When the grantor is alive, in a lot of trust documents I will permit the grantor to, I don't mean I will, but we'll draft into the agreement the permission for the grantor to select a successor trustee, if not the grantor, I mean the grantor's spouse, for example. So if it's a lifetime trust that I've set up while currently, I may have, or my spouse may have, the power to change the trustee. But after I'm gone, that really kind of is a break point there, and you really have to decide who you're going to give that power to, because any number of things can happen. You can have the greatest corporate trustee named in your document, and then who knows who may acquire them 10, 20, 30 years from now, and maybe it's not a great fit for the family at that point. So there's a couple different ways you can go. You can give sort of the adult beneficiaries voting, in a majority or even unanimously, the power to remove and replace the trustee.
I see.
But that's putting a lot of the control in their hands, so they kind of pulling the strings on the trustee a little bit if they have that power to pull the rug out from underneath the trustee. Another way to go is what's become a fairly common concept is a trust protector, and that's it's kind of a misleading name. His or her job is not to truly protect the trust, but frequently this person has the power to remove or at least select a successor trustee. So, and you can split those up. You can give the beneficiaries the power to fire the trustee, and you can give another person the power to appoint a successor, so not all of the power is lodged in one group.
I see. So we've been sort of discussing who the trustee is, what your choices are, the flexibility in changing trustees, and so forth. Help us get a feel for the duties and obligations of a trustee. And I guess we're sort of putting on our trustee hat. Imagine you're a trustee now, and what are your responsibilities, obligations, and liabilities at this point then?
Well, there are a number of fiduciary duties. Probably the first one that jumps out is just the general duty of administration, the duty to administer the trust with care, and that is really as simple as keeping good books and records, having systems in place to keep track of all the documentation requirements. You have to provide accountings to the beneficiaries. You have to provide notice for certain events, and you really need a good system to keep track of all that paperwork, documentation. And then, of course, you have a duty of something that's called a duty of impartiality, which is the duty to not favor one group of beneficiaries over another. So, for example, kind of the typical way this duty rears its ugly head is maybe a second marriage, a spouse for the surviving spouse, a trust for the surviving spouse that provides all income to that surviving spouse, and then the remainder of that trust will pass to children. I'm sure this is something Phil's seen a number of times. Will pass to children of the first marriage, and so as you can see, there's not much explanation necessary there. The surviving spouse has, and the surviving spouse is very much interested in current income and investing towards that.
Right. And
the remainder beneficiaries are very concerned that the assets are invested in a way that they'll grow.
Yeah. It seems like we're talking about sort of some of the tensions that can exist by virtue of a particular trust structuring, where you've got competing interests between the current income beneficiaries and the ultimate principal beneficiaries, if you will, who are further down the line. And I think we've all experienced that quite a bit. and I think that kind of probably leaks into investment management and the type of investment management that you look for with those two competing interests there. But before we veer off into that, I just wanted to touch on this subject here that I think I kind of skipped over. Now, as I understand it, through prior conversations with you, Bob, we had talked about so-called co-trustees as well. You can have more than one trustee with different areas of expertise there. If you could talk a little bit about that.
Sure. There's a couple ways to go here. You know, I mentioned earlier you have an individual trustee, or you could have a corporate trustee. Well, that's not the whole story. You could, of course, have both. You
right.
could have, you could name a child as, when I say child, it could be any individual. So perhaps the trust is for children, perhaps it's for nieces and nephews. But you can name that individual as a trustee and then name a bank or trust company as a co-trustee. So you kind of get your cake and eat it too. You've got someone that can provide that personal touch, and then someone that can provide that rigorous structure and all the accounting and back office and tax prep and that sort of thing. Another way you can go with co-trustees is to sort of split up the duties. So you could name the individual trustee, for example. You could give that person the responsibility.
Very sorry for the interruption, everybody. We had a little technical difficulty there. So we'll resume the webinar now. Have fixed our issue here, so my apologies. We'll edit that out in the recorded version, obviously. And so to sort of pick up where we left off, Phil, if we could bring you in at this point to sort of talk about some of the issues and challenges and the investment process around managing trust assets, we'd appreciate that greatly.
Yeah, absolutely. First of all, I had about 15 years experience in managing trust type of portfolios, and pretty much have seen a lot of interesting sorts of things. I just will comment quickly on the trustee situation, and again, this is anecdotal, but from what I've seen, when people name one of their children to serve as a trustee, it usually doesn't work out, particularly if they have other children. There is a conflict, and usually creates problems. And so I always sort of tell people that it's sometimes better to have a corporate trustee, simply from the fact that if the family is not sort of quite happy with what it is that's going on, they don't take it out on one of the siblings, you know what I mean, who is the
Sure.
trustee. They take it out on the corporate trustee. Very often we have what's called a dual interest trust, and Bob can probably describe a little better what a dual interest trust is. But in essence, all it really simply means is that there's a income beneficiary, current, and also a remainderment. And this is a very typical type of trust set up by somebody who has maybe a second wife and children from a first marriage. And here, the individual wants to take care of their first wife for the rest of their life with the income from the trust. And then at their passing, anything that's left goes to the children. Obviously, this creates somewhat of a conflict because, of course, the remaindermen, the children, want to make sure that the trust grows, while the income beneficiary wants to have as much income as they possibly can have. So, designating a corporate trustee is a good way to go, because we can kind of take the heat and do what it is that's right, in terms of the trust. We have to follow, of course, the language in the trust. All trusts are created, although similar. Some have more liberal language in terms of invasion clauses and things of that nature. So we have to go ahead and follow that very closely. From the investment side, we really need to make sure that we manage the trust as a fiduciary. There is something called the Uniform Prudent Investor Act that we must follow. That is set up by Florida law. And by the way, trusts are reviewed not just simply by the internal, staff of the bank, but they are reviewed generally on an annual basis. Although I've seen it a little bit longer, sometimes 2 years. By what we call the OCC, or the Office of the Comptroller of the Currency, which is actually a department of the U.S. Treasury. And they will come in and actually audit just about every single portfolio to make sure that the investments in the portfolio are indeed diversified and the portfolios are set up correctly. So you really need to make sure that you're on your toes. Again, I've spent over a week in an office with the OCC regulators, just going through one portfolio after the next, making sure that everything was in order. Just to talk a little bit about a trustee, though, the trustee really has the power to invest and manage the trust assets like a prudent investor. By exercising reasonable care, skill, and caution with regard to trust objectives, by considering the general economic conditions, the possible effects of inflation or deflation, the expected tax consequences of investment decisions or strategy, the role of each investment or action within the overall trust portfolio may include financial assets, interest in closely held enterprises, personal property, and realty. Expected total return from income and capital appreciation, and of course any kind of needs for liquidity, income, regularity, capital preservation, and appreciation. One of the big things that we see a lot in the trust business is people bringing us portfolios that have what we call concentrated positions. And these are generally defined as any one single stock or investment that represents more than 10% of the total assets of the portfolio. Now, that's using a pretty strict definition. Usually it's a little bit more than that we'll get excited about. But very often we see a portfolio that comes in that has over 50% in one stock. And the reason may be is the individual, the grantor of the trust, likes that company. The individual wants to keep that. There is actual language in the document to allow the trustee, the corporate trustee, to hold on to that position. There can be a whole bunch of different factors. One of the things that we have always strived to do, even if it's in the language of the document, to hold on to a concentrated position, we have a duty to go ahead and diversify. That's one of the main tenets of the prudent man rule. And again, anecdotally, over the years, I have had portfolios with massive concentrations in Fannie Mae. Fannie Mae is now bankrupt, and fortunately, we did dilute that portfolio of the Fannie Mae. Sears Holdings, I used to manage money through the Sears heirs. We went ahead and diluted that. Citigroup and the banking stocks, B of A, for a while we were having portfolios that had massive concentrations in many of these bank stocks since they had such a great run. And of course, we would mandate that we would have to dilute these positions. And generally, when we dilute them, we bring them under 10%. And then in terms of the sector weighting, if there's a number of bank stocks, what we like to do is match it up to the S&P and say, well, if the weighting in financials in the S&P is 17% right now, we'll allow the portfolio to have up to 20% in bank stocks, but that's it. And we try and put some sort of a curb on it. Another good example was, of course, pre-2000, the technology stocks. We had many people bring in portfolios that had massive positions in Sun Micro, in JDS Uniphase, and all those that are now, unfortunately, just about worthless. So it is usually a good idea and a prudent idea to allow the corporate trustee to dilute the position. There are a number of ways that they can do it. Very often we would use something called a costless collar. And this may sound like a technical type of term. It really isn't. All we're doing in a costless collar is taking a portion of the concentrated position and basically writing calls against that, and then using the premium from the calls to go ahead and buy puts to put a floor underneath the stock. The individual is allowed to continue to receive the dividends during this period, and over time we try and work out of the position. We have a program in place. Sometimes it can last 3 to 4 years, where we dilute the position, slightly every single year. But it is important to certainly do that. And if, again, many people, for whatever reason, have affinity for certain positions in stocks, it is something that most trust companies, again, with that mandate that they have to diversify, are really unable to go ahead and hold those type of positions. In terms of the dual interest trust, remember, we have to kind of separate the income from the principal. So the income beneficiary is able to get any of the income that is generated, and then the remainderman will get whatever it is that's left over. Now, in this day and age, of course, there are many things that are hybrids, meaning there are types of securities that are both income and also growth vehicles as well. There, the portfolio manager has to use some sort of discretion. A good example here are MLPs and things of that nature. Generally speaking, though, the income that would be generated would be mostly from bond-oriented type of investments, and also dividends from individual stocks. That would make up most of the income beneficiary, income for the income beneficiary. Often the income beneficiary is somewhat wants to have the income increased, of course. We try and do the best that we can, but remember, as a portfolio manager and as a trustee, you have to balance the interests of both the income beneficiary and the remainderman. So it's important that you maintain that balance, even though you may be getting pressure from either side. And that brings me back to my original point. The pressure that sometimes can happen between the income beneficiary and the remainderman, if you have a corporate trustee, I think it makes it a little bit easier, because that's kind of what we do for a living. If you have a, either a child, your son or your daughter acting as the trustee, that's a lot of pressure on them to make those types of decisions, and very often it causes conflict within the family that I've seen, not always, but often, and can be very sort of stressful for the individual to try and manage the trust in the way that it is supposed to be. So that is just a couple of comments on that. And Bob, I don't know if you want to chime in at all with a couple other things on that. But.
Yeah, first of all, just great point on the naming the child as trustee. Certainly if you have a trust for the benefit of, say, 3 or 4 children and you name one of them as trustee, you're building in some resentment from the get-go potentially. A lot of times what I try to do is have the trust split into shares, 1 share for each child, and then permit that child, whether it's upon reaching a certain age, say age 30, 35, permit that child to become a co-trustee at that time, so he or she has some say over the trust. And that works really well in cases where you've got a corporate trustee and you just want to ensure that that child/beneficiary will have some input there. So, but great point for bringing that up, Phil. Thank you.
That's a great point, both of you. I was gonna ask this question of either one of you or both. So Phil, you talked a lot about dealing with the various investment implications inside the trust assets and so forth, and that it was fantastic. Who actually dictates the asset allocation, and who determines how much income is enough, or sort of sets the bar for that? And then a related question to that is, who monitors the ongoing investment management? How does that all work?
Do you want me to take that?
Yeah, sure. Go ahead, Bill.
Yeah, sure. Well, first of all, who monitors it? Basically, the bank. Now, in the bank, of course, the portfolio manager and the administrator are the first line. There are also things that meet on a quarterly basis called trust committee. I think it may be called other things in other trust banks, or trust organizations, where the portfolio is brought out in front of a number of trust officers, and it is reviewed not just by the portfolio manager and administrator, but other senior level trust officers to ensure that the language in the trust, as well as the structure of the trust, is in good standing. I also mentioned too that the Office of the Controller of the Currency will come in and actually audit the actual portfolios. And as I mentioned before, I've sat in the office for over a week in a small office with them and went over every single trust portfolio that we have from the investment standpoint, and making sure that we had all of the portfolios in order. Generally speaking, Brad, to answer your question about how much income, that's a little bit difficult question. Generally, when you have a dual interest trust, essentially we split it right down the middle. So 50% is in income, and then 50% is in growth or stock. And, that basically balances exactly, you know what I mean, the interest of both sides. Of course, the income benny is going to have the right to the dividends as well. So we try and sometimes help out the income benny by having higher income dividend-oriented stocks. But we do adhere to some pretty strict rules in terms of the credit quality. We generally don't use, any type of junk bonds or disallowed and things of that nature. And it is what it is. Unfortunately, right now, with the low income, with rates, at all-time lows, it is difficult because many of the income beneficiaries really don't get as much income as they think they should be getting. $1 million portfolio, and if you have it in high-quality bonds, 50% isn't really going to yield that much.
Sure, sure.
In cases like that, we will try and do the best that we can to augment that. But again, we have to keep in mind that we do have a fiduciary duty to the remainderment as well,
sure,
growth, so that we cannot violate one side's rights here to favor the other side. And it becomes difficult, and these are the things that can create hostilities. I don't want to use the word hostilities, but certainly
tensions.
Maybe some discontent on the part of the income beneficiary or the remainderment. But again, it leads me back to the reasons why you want to have a corporate trustee, is that if there is a problem and someone isn't happy, they come to the corporate trustee and they complain. You know what I mean? Some of them bitterly complain. That's not uncommon at all. That's actually more of a common thing. But what happens here is that it's much easier for us to deal with it than it is, like I say, for a sibling, for a family member who really doesn't understand trust. You know what I mean?
Sure.
They can easily make mistakes by, sort of mismanaging the trust where they favor the income beneficiary.
Right.
And then, of course, later on down the road, the remaindermen come back and say, well, geez, the trust isn't worth anything. What happened? And, there's a lawsuit there. Do you know what I mean?
Yeah. So
the person did not handle the trust correctly, and there's a liability. So it's a very tricky thing, and you really don't want to put somebody in that position who doesn't sort of understand all of the nuances about how these things work.
Yeah, I think that was excellent. I think the two points I drew out of there to extract, Phil, just to summarize, is number one, you have to be careful, especially in this low interest rate environment, that as you reach for yield for the current income beneficiaries, you don't put at risk the erosion of trust principal in the process, because that can create issues down the road for the remainderment of the trust. Mm-hmm. And then secondly, I wanted to direct this question over to Bob. What about in the case where we've discussed how it's a good idea to have a corporate trustee involved, either as the primary trustee or a co-trustee, but what in cases where there is no bank trustee, but it's an individual, and maybe that individual doesn't have acumen in the area of investments? Maybe they're a physician, maybe they're a lawyer, a school teacher, an artist, et cetera, et cetera. How would it work in that case, Bob?
Good point, and I guess the larger point Phil just raised is it's being a trustee is a big job, and if an individual is going to serve as trustee, that individual certainly needs to be financially savvy, great attention to detail, very prudent person, really somebody that would treat the assets as if, not as if they were his or her own, but as if he were guarding those assets for another, which is exactly the case, of course. When you have a corporate trustee, that's what you're looking for. You're looking for a lot of those safeguards, the things Phil mentioned, sort of running the portfolio in front of all of the other different trust officers just to get that feedback. But when you have an individual that's named as trustee, the odds that that individual is also going to be an expert portfolio manager, those are pretty slim odds. So there are a couple things you can do. What we started to mention before we had some of our audio troubles is you can, of course, name a corporate co-trustee to provide some of that backbone to go along with the individual. Another idea or another tool that we have to combat some of that tension we're talking about between the income and the remainder beneficiary is you can give the trustee discretion to distribute income or principal, and that takes away some of that tension in many cases. And you also have a tool called a uni-trust, which effectively says distribute 2, 3, 4% of this trust every year regardless of income or principal, and that way you can really invest for investing's sake and not be so concerned with reaching for yield, as Brad mentioned. But these are all pretty heady concepts for most individuals, and I think that it becomes really important for an individual trustee to find a portfolio manager. And one of the things that we like to talk about with clients a lot is the trustee has the ability to fully delegate investment responsibility to a portfolio manager, and then the trustee's duty becomes not to sort of guarantee the performance of the portfolio, but the duty sort of shifts to choosing the right manager, and that's something that we've talked about, Brad.
So Bob, it sounds like what you're describing is a trustee is fully able to, if they don't have the expertise to manage the investments, really their obligation then turns to one of due diligence in selecting an investment manager to run the portfolio for the beneficial interests of the income beneficiaries and those beneficiaries down the road as well. Because I think that was my question, is I'm a grantor of trust assets. I take these assets and I put them in a trust, and then I die. What assurances do I have in that case that the trust assets are going to be managed? How do I know how they're going to be managed, and so forth? And I think both of you did a great job touching on that.
One thing I will add, Brad, if I can.
Yeah, please.
The trustee can delegate the investment management responsibilities. However, there's a big caveat there. The investment manager still has to follow the basic trust guidelines of the trust. It doesn't mean that the investment manager can just invest however they want. Meaning if it's a dual interest trust, the investment management has to abide by that.
Right.
Sometimes people don't realize that, and they think, okay, well, I've delegated to this investment manager, which is fine. However, that investment manager has no idea what the language in that trust is or what the guidelines in the trust are, and that can become a major problem, particularly if the trust is managed in a way that possibly the remainder men are not left very much. Do you know what I mean? Or
sure.
Along those lines. Mm-hmm.
Absolutely. That makes a lot of sense. It sounds like it's important to establish a written and monitored investment policy statement that is consistent with the language embedded in the trust as regards financial management. Would you agree with that, Phil?
That's well said. Exactly. That nails it. And the other thing I just want to add too, and I'm sure Bob can kind of expound on this a little bit, but in many trusts, they have language which allows for the income penny or even the remainderment in some cases, invasion clauses. You know what I mean? So there are certain things that would allow them to go ahead and take money out of let's say, the principal portion of the trust. So you have to be sort of aware of that as well, and of course provide liquidity, things of that nature. Many of those things, though, have to be interpreted in light of the trust.
Sure.
And that's where, an administrator and, legal team kind of look at it to really, somebody like Bob would look at it to interpret what that language really means, you know what I mean, and how best to allow it to go on in the trust. And I've seen many, many cases where the invasion clauses are somewhat ambiguous, you know what I mean, and it really is difficult for the trustee to determine what is the right thing to do.
And Phil, that seems to be where I've seen language in terms of trust invasion for health maintenance and support, those types of that type of terminology in the trust is what you're referring to, I believe.
Yeah, things like that. Also, even broader things, that the individual should be kept in their own lifestyle. You know what I mean? Things of that nature, which
yes.
are totally ambiguous. You know what I mean? What does that mean?
Right,
it's
right.
difficult to understand that. So,
I would also encourage our listeners to possibly refer back to the first session that we did a few weeks ago, where Bob and I talked about the concept of decanting also, and those types of things. Which we won't go into detail again today, but that's sort of a related issue, I think.
Right. It's just a number of ways to deal with a trust that was maybe drafted a long time ago and isn't quite up to speed in terms of modern realities.
Mm-hmm. Mm-hmm. I can tell you this. It does get sometimes a little bit hot. Again, I've got a lot of anecdotal stories here. I won't bore everybody with them all, but back in 1998, 99, we had a number of trust clients who were up in arms that we were not overweighting technology, you know what I mean, that we were keeping a diversified portfolio. And some got to the point, I had one woman who called me every single day complaining and wanting, she had no idea what JDS indices even did, but all she knows is that she wanted it in her portfolio.
Right, right.
Okay. And one of the things that's, I think, really a benefit of using a corporate trustee is that diversification. And again, I can't tell you how many people, have been saved by, thinking that they had the greatest stocks of, who would have ever thought of Citigroup, you know what I mean? Who would have thought maybe of the technology names, Sears, Fannie Mae, General Motors, the list goes on. And these are all great companies, and the grantor of these, these trusts think that, Eastman Kodak, think that, these are companies that are going to live on forever and name those in the trust, but things change, they really do, and
sure.
Unfortunately, what seems right today may not be right tomorrow, and the trustee has to sometimes take action even against language that's in a document, believe it or not. We've had to do that before. The trustee will go to court to before a judge and ask to enable us to diversify the portfolio away from the concentration.
Right.
Mm-hmm.
That makes sense. That's all great points, Phil.
Mm-hmm.
Well, I think we've been going for about 45 minutes, so I think we'll wrap this one up. We'll be doing the next session in the series that is, of course, going to be related and an add-on to the first two sessions for those that would like to follow along with the series. And you'll find the recorded version of this edited for the technical difficulty that we had midstream on the Capital Rock Investments website as well as the Oakstone Law website. And so with that, I think we'll close the webinar and thank all of our participants. And if you have individual specific questions, feel free to reach out to Phil Morrissey with Capital Rock Investments in our Aventura office, or Bob Kleinecht at his office here in Naples, or myself in the Naples headquarters of Capital Rock Investments. So thank you very much, and everybody enjoy your day and your week.
Thanks, guys. Take care.
You too.